So welcome, everyone. I am Laurel Elder. I am professor and chair of the Political Science Department, and I'm so glad you guys could all be here today on this Friday afternoon. So before I turn to Hartwick student, Tori Balfe, who is going to introduce our guest speaker, I wanted to say a couple things. First, thank you to all of those who made Geoff Korn's return to Hartwick possible, the Office of Academic Affairs, the Sociology, Criminology, and Human Services Department, the Sociology, Criminal Justice, and Political Science Clubs, my colleagues in the Political Science Department, Career Services, Facilities and Catering, Chris Spiewak for his amazing technology wonders, Communications and Alumni Affairs team for helping promote his visit. I also just wanted to share a brief story. As I think many of you know, Professor Korn has been on campus yesterday and today speaking to classes and hosting lunches, and it's really been an amazing couple of days. And at the end of our lunch yesterday, Professor of History Kyle Burke, who's here with us today, and who studies the Cold War, and Professor Korn got into a really deep discussion about international law and war crimes and the 1949 Geneva Conventions and the 1977 amendments to the Geneva Conventions. And it was, some of you were there to witness this, it was really amazing. And I will say that Professor Burke later stopped by my office and he said, you know, what is the secret? How did you get such a heavy hitter to come here to Hartwick and give this talk and engage with our students? And I said, well, that's a really good question. What would possess the chair of the criminal law department at Texas Tech to board a plane in Lubbock, Texas, and make his way to upstate New York at an incredibly busy time in his own semester and spend 2 full days at Hartwick? And I think the answer has something to do with something Professor Korn said in my Courts and Judicial Politics class yesterday, which is, I hope it's okay that I'm sharing this. He said that when he started at Hartwick, he was an okay student, but he was a little bit more interested in football than the intricacies of international law and the Geneva Conventions. But he said Hartwick totally transformed my life. And it helped him become the extremely successful, extremely disciplined person he is today. And I think by being here with us today, this is his way of saying thank you to Hartwick and for giving back and of showing his gratitude. So that's the secret. And now I'd like to welcome Tori Balfe to the podium to introduce our speaker. Tori is amazing. She's a political science major, a legal studies minor. She's a 3-year student. She's a swimmer. She's involved with mock trial. And as soon as she arrived on campus, she has been a force. I remember as a first-year student, she organized this amazing event on the hate you give and a discussion of race and policing. She found herself an amazing internship this past summer with the Michigan DA's office. And she has basically been enthusiastically throwing herself into every opportunity Hartwick has presented to her. So please help me in welcoming Tori Balfe to the podium.
Hi and welcome. Thank you, Professor Elder, for that wonderful introduction. Like she said, my name is Tori Balfe. I am a junior political science major here at Hartwick, and I have the great honor of introducing our guest speaker. Professor Korn, like Professor Elder mentioned, is an alum of Hartwick College, and he earned his law degree from George Washington University. After that, he went to serve for the U.S. Army for 21 years. He has done a lot in his professional career, from serving as an expert witness at the Military Commission in Guantanamo to serving as chief prosecutor for the 101st Airborne Division to teaching law to those in the military and in law school. Professor Korn is currently the George R. Killam Jr. Chair of Criminal Law and the Director of the Center for Military Law and Policy at the Texas Tech School of Law in Lubbock, Texas. Professor Korn is also dedicated to working with students, not only at the schools that he teaches at, but also here at Hartwick. Last year, I was seriously considering joining the JAG after I finished law school, and Professor Elder gave me Professor Korn's contact and told me to reach out, and he took the time to talk with me and give me advice, not only about joining JAG and what that's like, but also about law school, finishing my degree, and I had been on and off about finishing early and that sort of thing, and it was really nice to just talk to someone who had been through what I was thinking about doing. I'm very glad that he was also able to make the trip out to Hartwick. He had talked to me when we talked in the spring about maybe making something happen in the fall, and he's been able to spend the last couple of days talking with multiple classes, having luncheons. I was able to be in one of those classes, and just talking with us about career paths and what law school is like for those of us who want to go to law school and that sort of thing. His talk today is titled War Crimes Accountability and the Conflict in Ukraine. This is an issue of strategic as well as moral importance to the United States as well as to all of us as humans. Being able to fully understand what's going on in Ukraine right now will especially be helpful for students due to the fact that this is something that could potentially be affecting us for a long time. As a student, it's also really important to have an up-to-date understanding of current events on a global level. I know in political science we talk about current events a lot, but please join me in welcoming Professor Korn.
Well, let me start by saying the thanks are all directed to you to give me the opportunity to come back. I mentioned to a couple of the people I spoke with that I learned very quickly when I left Hartwick in 1983 and went in the Army that the Hartwick community is very limited to the kind of tri-state area. And when you're living everywhere from Panama to Arizona to Georgia to Germany, you don't have that real sense of connection, and that was before social media. And I'm just so grateful to all of you, and especially to you, for giving me the opportunity a couple of years ago to come back and then setting up this opportunity for me. I mean, it's a gift for me to be able to meet students like this and spend time with them. And I really can't overstate that my passion is teaching. And, you know, I had a professor at the JAG school. He was a professor of education at the Curry School of Education at the University of Virginia. And he used to tell us, he would do seminars on teaching, and he used to tell us that teaching is like throwing a penny over the Grand Canyon, right? You're not going to see its impact, but you can be sure that it will have an impact. And that's the joy of it. So, you know, I may never see many of you again. I hope I get to see some of you again. But if I don't, I hope that something that happened in the last couple of days had some small impact on your future, and someday you'll pay that forward as well. And it's true. Hartwick did definitely transform my life. I mean, you were generous. I didn't say I was an okay student. I said I was a terrible student in high school. I was very lucky that Hartwick gave me the opportunity. I told some students this morning, I was so afraid of flunking out when I first got here that I worked tirelessly, and then I did pretty well, and that was kind of like, wow, it's kind of nice to do well. And I was so grateful for the professors I had here, and it was the perfect fit for me. You know, I'm at a university now that, but for the Air Force Academy, is physically the largest campus in the United States. It's massive. I would have been lost there. I would have just disappeared in the crowd, and that doesn't happen here, and I saw it happen in the classrooms over the last couple of days, and I think that I was lucky to be here, and I'm lucky for this connection. And if anything, I feel a sense of that I haven't given enough back, right? So coming here is just a joy, and I hope to get to do it again in the future. But when we first spoke, what I mentioned was there's a lot of interest, I think, now in what's happening in Ukraine and what we see in the news every day, and how does law actually affect this? We see people talking about war crimes. We hear the Secretary of State, the President of the United States, the President of Ukraine constantly referring to war crimes. And we see things that logically generate a visceral reaction. This can't be right. This can't be okay. And how does this system actually work? So what I want to do today is, and I'll try and, ta-da, okay. What I want to do today is give you an overview of the law that regulates the legality of launching an attack, right? When I was a JAG officer, that was part of my function, that I would sit in what was called a targeting meeting with the commander, the operations officer, the intelligence officer, the weapons officer, the air officer, and we would plot out, here are the targets that we have to address, and then my job was to give the commander the legal framework that he or she had to comply with in order to comply with international law and our obligations. Some of the discussions we had yesterday really focused on kind of the inherent, let's be honest, some of the inherent hypocrisy of the United States demanding other countries comply with rules that sometimes we don't. But I will tell you, at the implementation level, at what we call the operational level of military action, that's never a debate. Okay, we never sit around and say, well, we can get away with violating the law, so let's do it, right? As a lawyer in the Army, I had an ethical obligation to represent the United States government. That was my client, not the commander. And, you know, as a military lawyer, you're in a really unique situation because if your commander ignores your legal advice and says, I'm going to do something because I want to do it anyway, you are the only member of that staff who has the obligation to go over his head and go and look at him in the eye. You know, you're a captain and you're looking at a colonel and you're saying, Colonel, if you persist in that, I'm going to the general. And man, that's not an easy day, because they're not used to that. When I was an intelligence officer, I could never do that. I would say to the commander, here's where I think the enemy is. And he would say, but I think the enemy's over here. I couldn't say, well, I'm going to the general and telling him that you don't know what you're talking about. But my duty was different. My duty was to ensure that the units and the officers that I advised complied with law, domestic law and international law as it's understood and adopted by the United States. So what I'm going to do is give you a very brief overview of the methodology of how we assess the legality of a target. Then what I'm going to do is shift to explain to you how the International Criminal Court seeks to criminalize violations of these regulatory norms, right? Because ideally, if you think about it, the law of war should never lead to a prosecution. It's a regulatory source of law. We're supposed to follow the law, and we shouldn't have prosecutions. But there's a shift that happens when we take these regulatory norms and we transform them into standards of criminal responsibility. And I think you'll see how that shift makes it much more challenging to criminally convict somebody for violating these rules than to simply say there was a breach of the norm. I'm going to explain to you a little bit about the International Criminal Court, how it gets jurisdiction, who's subject to the court's jurisdiction, and what are the most relevant offenses in relation to what military lawyers call the conduct of hostilities. When we talk about rules of war, the law of war, what most international lawyers today call international humanitarian law, there are really two broad categories of law. There is the Geneva tradition, which is focused on the protection of victims of war, people who've been captured, detained, subject to enemy occupation, the wounded and sick on the battlefield. The first Geneva Convention of 1864 was to protect the wounded and sick that are left on the battlefield because they suffer so terribly and there was no mechanism. So all of you have seen a movie or a TV show where you see a soldier wearing a red cross. That came from 1864 and the first Geneva Convention, the symbol of protection. And the wounded and sick and shipwrecked at sea. Those are the four categories of war victims that are addressed by each of those treaties. There's another branch of law that military lawyers normally refer to as Hague law, or the Hague tradition. That's the law that regulates the conduct of hostilities. Who, what, where, when are you lawfully allowed to attack, right? So when you see people on the news say this attack violated the Geneva Convention, I get it. The idea is that it's inhumane, but really, no, the Geneva Conventions don't tell us how to fight. They tell us how to treat victims. The Hague tradition tells us how to fight, and then you'll see that there's a 1977 update to the Geneva Conventions called Additional Protocol 1 that the United States helped write, unsurprisingly never ratified, because as I was speaking with one of your colleagues today, the United States has this tortured relationship with international law. We get involved in developing it, and then we kind of pull back. And then for the people in the military, the government says, okay, we're not party to the treaty, but most of it reflects customary international law, so you have to follow it anyway. So for us, it's kind of transparent. We know. we're going to follow the protocol even though we're not bound by the treaty. And then I'm going to talk to you about a real problem with war crimes accusations and condemnations, and it's what I call effects-based condemnation. And you'll understand that when I explain to you the crimes themselves. And then if I have time at the end, I'll talk to you a little bit about U.S. jurisdictional options for dealing with war criminals. If you want to interrupt me during the presentation, it's not going to bother me. I'll try and save some time at the end for questions. But if you have some burning question or comment, just chime in. Let's start with a basic rule of war, military necessity. Military necessity is the foundational justification for all violence in armed conflict. And this is the definition that comes from the Department of Defense Law of War Manual. By the way, when I teach this subject to law students, they are stunned how much law there is related to war. The DoD Law of War Manual is about 1,400 pages long. It's massive, right? It's a treatise. And there is a lot of law here, but the very foundation is this rule. Military necessity may be defined as the principle that justifies all measures needed to defeat the enemy as quickly and efficiently as possible that are not prohibited by the law of war. So let's take that apart for a minute. All measures. You are allowed to do anything you determine is necessary to bring about the prompt submission of your enemy. And the enemy is a collective entity. This is not like a police officer using force on the streets. When a police officer has to use force against a citizen, it's because that individual has deviated from the law and there's an imminent, immediate threat that requires that use of force, and the rule of proportionality protects that individual. That's why we always ask whether the officer used excessive force, correct? That's why we give police officers tasers. I never carried a taser in the Army, because I don't have an obligation to use proportional force against the enemy. I have an obligation to consider the effect of the attack on the civilian population. But if it's enemy, I can use all the force I think is necessary to bring about the enemy's submission, and I'm not just worried about that one enemy soldier. I'm trying to get the enemy as a corporate entity to submit to my will. That's the principle of military necessity. Look at the end, though. Not otherwise prohibited by the law of war. That comes out of the Nuremberg tradition. The German war manual in World War II had a concept called Kriegsraison. Kriegsmanier, or Kriegsraison geht Kriegsmanier. Basically, the logic of war necessitates the rule of war. And when the German defendants were put on trial at Nuremberg, they frequently invoked this rule and said, I did it because I had no choice, right? The high command case, where German generals were prosecuted for murdering thousands of Soviet prisoners of war, which was prohibited by international law. And their defense was, what was I going to do? I didn't have enough people to guard them. I didn't have enough food to feed them. I had what? I had military necessity. And the Nuremberg Tribunal rejected that. The Nuremberg Tribunal concluded that where there are absolute prohibitions in the law, you can never invoke necessity to justify violating them. So if the law says you are not allowed to torture, and you're Alan West, the congressman from Texas, who puts a gun to a detainee's head and says, if you don't tell me where the next IED is, I'm going to kill you. And then he says in his disciplinary proceeding, I was just trying to save my soldiers, that's illegal. You cannot invoke military necessity to override an absolute prohibition. No murder, no torture, no cruel, inhumane, or degrading treatment, no collective punishment. You have to care for the wounded and sick. Once somebody is out of combat, you're not allowed to attack them. I was telling students yesterday in one or two of the classes about a case I worked on where an American captain in Iraq committed a mercy killing. And a lot of students say, well, it's war. Aren't you allowed to kill the enemy? Sure, you're allowed to kill the enemy, but once he's laying on the ground convulsing, he's not the enemy anymore. He's a human being again. And you're prohibited from doing that, and you can't invoke necessity. But if it's not an absolute prohibition, then the commander is going to say, do I need to do this to defeat the enemy? The basic principle of military necessity. Now let's look at how this principle is translated into target selection and engagement. We'll start with attacking a person that's nominated as a target. There are basically two categories of people on the battlefield, civilians and belligerents. Belligerents are members of the organized enemy armed forces, right? A soldier an Al-Qaeda fighter, a Taliban fighter, you make a reasonable judgment that the person you're dealing with is subordinate to enemy belligerent leadership. If I identify you as a belligerent, that alone justifies my use of deadly force against you. I can do it when you're sleeping. I can do it when you're running away. You are a target unless and until you surrender or you're wounded or disabled from sickness. Belligerent targeting. Now, you can imagine that it's easier when you're fighting a uniformed enemy, because the uniform tells me. That's why we don't wear uniforms to hide from the enemy. I mean, let's be serious. We wear uniforms so that the enemy can tell the difference between you and me. That's called distinction, the fundamental obligation of the law. Everybody else is a civilian. Civilians are presumptively protected from attack. They can lose that protection if they do something called directly participate in hostilities. That means they do an act that is directly linked to causing harm to your forces. So if I were walking down a street in Iraq and a civilian picked up a rifle and started to shoot at me, I'm not going to hide behind a tree and say, I wish that were a soldier so I could shoot back, right? I have a right of self-defense at that point. But normally civilians are off limits. So if it's a civilian, you stop. If it's a belligerent, the next question is, are you using a lawful weapon? Believe it or not, every weapon system that's fielded in the U.S. military undergoes a legal review to make sure that it complies with international law. That used to be my job in the Pentagon. I would review, the program managers would bring the new weapon to me and I would review it to make sure that it can attack the enemy precisely, distinctly, and it doesn't inflict unnecessary suffering. Suffering that is superfluous to the goal of disabling the enemy. For example, back in 1899, they prohibited glass projectiles. Anybody think why? What medical technology was just emerging in 1899? X-ray. What can't an X-ray see? Glass shrapnel. So you could use metal shrapnel because if the enemy wasn't dead, then he has a chance of being cured. But if you use glass shrapnel, the theory is what? It's calculated to cause more suffering than is necessary. So the weapon has to be legal. The next question I ask is, will attacking this belligerent create a risk to civilians? Notice if the answer is no, I'm done with the legal analysis. Because I don't have to worry about proportionality. I don't have an obligation to capture. Once it's an enemy belligerent who I can attack without creating any risk to the civilians or the civilian population, it's a lawful target. The reality is in war today, that's very rare. Almost all attacks are going to implicate a risk to the civilian population. But if you find a Russian column in the middle of the woods and there are no civilians around, attack. Now, I'm not saying the commander has to attack. That's a policy judgment. There are a lot of times where a commander will say, no, I'm not going to attack. Let's try and capture them. We get intelligence out of it. And if we capture them, we can drop leaflets and tell other ones we're treating them well, and then they're more likely to, okay. That's your judgment as a commander. What I'm telling you is you have legal authority to attack at that point. If there is going to be risk to civilians, the next rule, which comes from the protocol, is that the commander has to consider implementing what we call all feasible precautions. Precautions are tactical measures that are designed to reduce the risk to the civilian population. So as an example, I was on CNN during the 2014 Gaza conflict, being interviewed by Don Lemon. So I'm sitting in a studio in Houston. I got an earpiece in my ear. I'm looking at the screen, but he can't see me. And during a break, it's about 3 o'clock in the morning in Israel, during the break, there's video clip of a huge explosion at Gaza University, big fireball. And Don Lemon goes, Professor, are you seeing this? I said, yes. He goes, we got to talk about that. We got to talk about this when we come back. So boom, we come back on. He goes, Professor, I'm showing this clip that I just showed you of this huge fireball in Gaza. It looks really scary. What's your reaction to it? I said, well, if I were a commander and I had to attack a target at Gaza University, would it be better that I do it at 3 o'clock in the afternoon or 3 o'clock in the morning? So that tells me there's a commander that's trying to implement a measure to mitigate the risk to the civilian population. And interestingly, the other participant was a Palestinian who said, listen, I've been at Gaza University and I know that Hamas uses some of the facilities to build rockets, okay? So what are feasible precautions? Things like timing of attack, the weapon system you use. You know, the military killed a high-level Taliban or al-Qaeda leader in Afghanistan a couple of weeks ago. They used a weapon. It sounds terrible. They used a weapon. It's called the Samurai missile. Have any of you heard of this? It's a missile that has blades at the end. So when it hits, right? You know why that missile was developed? To be able to kill one terrorist in an automobile without hurting his family, right? It sounds awful, but the idea is to give the commander an option that mitigates the risk to the civilian population. Timing of attack, weapon system, the tactic you use. We would say to the commander, look, this is what you want to achieve. You want to cut off rail traffic? Fine. But is there another place you can attack that will do it that won't hurt civilians? So choice of analogous targets, warnings, huge precautionary measure. When the Israelis conduct attacks in Gaza, they text message every citizen, every civilian, say, get out of this area, we're coming. Text messages, leaflets. Now the rule is the commander has to do it if he's got the capability and if it's feasible. What does feasible mean? That I can do it without compromising my military advantage. So if I'm going to do a surprise attack, I'm obviously not going to issue a warning, right? If I don't have enough precision-guided munitions for the operation, I don't have to use one on every target. This is just, this step, this precautionary step is the one commanders understand, because it's their world. I can figure out weapons. I can figure out tactics. I can figure out targets. Once you do that, then we get to the ultimate question, which is proportionality. And this is the most widely understood rule of war. Because when we think of proportionality, we tend to think of like criminal law, you're acting in self-defense, you have to use proportional force. So you can't use deadly force unless you're facing a deadly threat. That's not what it means in war. In war, what the commander has to do is he has to anticipate the risk to the civilian, and then he has to anticipate the military advantage from the attack and balance them. And what the law says is, if you conclude, this is all ex ante, before you do it, if you conclude that the harm to civilians or civilian property will be excessive in relation to the concrete and direct military advantage, then the attack is unlawful. It's considered indiscriminate. Notice the rule doesn't even use the word proportional. As a lawyer, proportional to me means close balance. Excessive means much more significant imbalance. That's the hardest rule for commanders to apply. Because collateral damage is not inadvertent. It's calculated. And just think about that for a minute. And the lawyer doesn't make this decision. The lawyer gives the commander the framework. And the commander has to make a decision. I am going to decide to launch an attack with full knowledge that it will kill 5, 6, 7, 8 civilians because I think that that's necessary to achieve my military objective. And if you've ever worked, I've dealt with commanders, I have a lot of friends who've done this, and they say these are the hardest moments these generals face, is launching an attack knowing the consequence of those attacks. So if you think about it, the rules of war, international humanitarian law tolerates the infliction of harm on innocent people. It's tolerable, so long as it's not excessive when you're trying to achieve a military advantage. If we do the chart for a place or thing, we get the same thing. It's the same process. Yes, sir?
I didn't want you to get too far. I just had a quick question on the distinction between civilians and belligerents more generally.
Mm-hmm.
So you said, like, so if a civilian picks up a gun and starts shooting at you, right? Okay, that's obvious. But there's
Gray
all
area.
kinds of things in between. They can simply be non-cooperative. They can block roads. They can do all. So is there a darker line? Is there a clear line we can draw? Or, like, does it have to be violent?
Yeah.
I was sort of curious about that.
So the organization that's responsible for like the guardians of the Geneva Conventions is the International Committee of the Red Cross in Geneva. The International Committee of the Red Cross, great operatives, field operatives, take a lot of risks. They have a really good law department. And normally what they're doing is they're basically talking about what you can't do in war, correct? About 15 years ago, they decided to commission what they called a project to develop the interpretive guidance on the meaning of direct participation in hostilities. And it was hard for them because what they had to do was write a report that said when you are allowed to kill somebody. That was inconsistent with their basic mission. There's been a lot of debate over that. I'd encourage you to look it up, right? You can get the report. It's just the interpretive guidance on DPH. Their view is there has to be a nexus to the conflict. There has to be a close causal relationship between the conduct and the harm to your forces. And what is very clear is that you can't say things like generally supporting the enemy war effort is DPHing. If I were at the JAG school, we would do problems, for example, that there's a guy driving a truck full of ammunition. He's a civilian. And we would say he is not a target because driving the truck is not close enough to harm to be DPHing. The truck is a target. The ammunition is a target. And he may be collateral damage if we attack it. But if I gave my students a hypothetical that said, the truck drivers are all sleeping in a tent the night before they move the ammo, can you just blow up the tent? We would say no, because they're civilians. Now, the U.S. view of it is more liberal than the ICRC view, maybe unsurprisingly. And one of the big things we say is if you're gathering intelligence. By the way, I saw the PBS documentary on Ukraine the other day, and this comes up there because the Russians believe that a lot of the civilians in the occupied territories are acting as spotters for precision artillery attacks. And I will tell you, if the United States thought a civilian were calling in artillery, that's direct participation in hostilities. And you lose your protection from attack. Okay? But it's very complicated, especially when you're dealing with an unconventional enemy like we did in Afghanistan, where everybody presumptively is a civilian, correct? Okay, so if we look at the way we deal with things or places, it's a similar test, right? The law says you must distinguish between military objectives and all other places and things. So the first question is, have you nominated a military objective for an attack? What's a military objective? Anything can be a military objective. A hospital, a church, a mosque, a ball field, anything can qualify as a military objective. The protocol creates a test for qualifying as a military objective. It's nature, location, purpose, or use. Nature means it's military in nature, like a barracks or a tank or an aircraft carrier. That's military in nature. Location, like a bridge. A bridge can be a military objective just because where it's located. I've got to prevent the enemy from using it. Nature, location, purpose is its future use. And use, how it's currently being used, offers the enemy a definite military advantage, okay, makes a definite contribution to the enemy war effort, and its total or partial destruction will give us a military advantage. That's how we decide what a military objective is. To be candid with you, it's not hard to say something is a military objective. I've seen lots of reports from Ukraine where the Ukrainians are highlighting that the Russians are attacking civilian power plants. Well, guess what? If it's a power plant providing power to the military, its current use makes it a what? Military objective if taking that power away gives me a military advantage. Now, there are some things that if they're being used for by the enemy, most notably a hospital, you have to give a warning first. You literally have to give a cease and desist warning. And by the way, who would do that? You're not going to like, hey, hold on a minute, I'm going to cut. No, you use the Red Cross. That's what they do. They'll go to the other side and say, the U.S. has evidence you're using the hospital as a command post. You need to stop it, or you're going to lose your protection from attack. But anything can become a military objective. And that's the first layer of analysis. If it's not a military objective, you cannot attack it. Full stop. It's civilian in nature. If it is a military objective, what's the next question? Just like with people, will attacking it create risk to civilians? If there's no risk to civilians, if it's an aircraft carrier in the middle of the ocean, attack. It's a military objective and there's no risk to civilians. And then if there is risk to civilians, we go through that same process. Have we implemented feasible precautionary measures? And if so, and we've exhausted them, Is there still risk to civilians? And if there is that risk excessive in relation to the concrete and direct military advantage we gain? Okay? This is the regulatory model for targeting. Now let's look at how the International Criminal Court turns it into criminal liability. We'll start by talking about how the International Criminal Court gets jurisdiction over a person. Now, to be very clear, the International Criminal Court is not the International Court of Justice. The International Court of Justice is an organ of the United Nations. It has no jurisdiction over people. I love watching the old generals, you know, they're on CNN, they don't really know what they're talking about when it comes to law. And they'll say things like, somebody should haul that guy in front of the International Court of Justice. I'm like, haul me in front of the International Court of Justice. I'll get a free trip to The Hague, and nothing will happen because they don't have jurisdiction over people. It's an interstate court, right? So Ukraine is suing Russia in the ICJ. That has nothing to do with criminal accountability. The Permanent International Criminal Court was created by the Rome Statute in 1998. We were a big player in developing it, but we're not part of the treaty. The Clinton administration signed it. Jesse Helms said, you're never going to get this through the Senate for advice and consent. Then President Bush was elected, and he officially unsigned it. I guess took a racer to, hey, bring me that document. But he told the world, we are not going to join the ICC. So the United States is not a party. But it was created, and almost all of our principal allies are parties. Our club is not that great, by the way. China, I think Iran, North Korea, Syria, Sudan, right? Saudi Arabia, not a good club to be in. Well, we'll just admit that, okay? Or maybe, I don't know. We could debate that a lot. We did yesterday a little bit. How does the ICC get jurisdiction over a case? There are two ways that a case can be brought before the ICC. The most common way is that the crime occurs on the territory of a state party or is committed by a national of a state party. What does a state party mean? You're a country that signed up to the court, or you've had acceded to the court's jurisdiction. Russia is not party to the ICC, but Ukraine has accepted the jurisdiction of the ICC, which means any alleged war crimes that occur on Ukrainian territory are now theoretically within the jurisdiction of the ICC. Offense in the territory or offense by a national, it should say national, I'm sorry. The other way a case can get before the ICC is the UN Security Council can refer it to the ICC. The UN Security Council, acting under its exclusive authority for the maintenance of international peace and security, can pass a resolution and ask the ICC prosecutor to take a case, even if it's of an individual whose nation is not part of the ICC, even if the crimes didn't occur on that territory of a state party. The president of Sudan, Bashir, is indicted by the ICC. Sudan is not a party to the ICC. The alleged crimes did not occur in the territory of a state party, but the Security Council asked the ICC to take the case. Now, that's not going to happen with Russia, because Russia has the veto. So the only way that the ICC prosecutor is going to get jurisdiction over a crime is if it occurs in Ukraine. 48 states that are party to the ICC have asked the prosecutor to open an investigation. There are two ways the prosecutor can open an investigation. Either he has to propose it and go to a pretrial chamber, it's like a probable cause hearing, and say, will you give me permission to investigate? That's what happened with Israel. The ICC prosecutor went to the pretrial chamber and said, I propose that you allow the ICC to investigate Israel, and the pretrial chamber gave approval. The other way the ICC prosecutor can open a case is if another state party refers the matter to the court. And this is unprecedented. There's never been this level of referral by state parties. 48 countries, last I counted, have said to the ICC, open an investigation into war crimes in Russia. Once that happens, the ICC prosecutor investigates the alleged violation and then seeks an indictment that has to be approved by the pretrial chamber. Once that indictment is approved, all the member states have an obligation to support the prosecutor, which means if the defendant ends up in any of those states, There should be a red notice at customs or immigration. You should be arrested on the spot and shipped off to the Netherlands where the court is located for prosecution. What are the most relevant crimes for the ICC? Let's start with this one, the crime of attacking civilians. Just take a moment and read, if you can, the elements. I don't want to read them to you. Don't worry about 4 and 5, okay? Here's the thing, two things I want you to notice about the crime. Criminal lawyers talk about crimes falling into two broad categories, conduct crimes and result crimes. Murder is a result crime. To prove murder, I've got to prove the criminal result, death of a human being. Reckless driving is a conduct crime. I have to prove you engaged in the conduct. Notice that the crime of attacking civilians is not a result crime. It is a conduct crime, which means I don't have to prove you did it. I don't have to prove you killed a civilian. I have to prove that you directed an attack against civilians. And then the other thing I want you to notice is I have to prove that you intended to attack civilians. People you knew were not belligerents, you knew were not directly participating in hostilities, and you had the subjective criminal intent to attack civilians. That is different than the regulatory norm. The regulatory norm is a reasonable commander standard. Did you do something a reasonable commander wouldn't have done? That's a recklessness standard. This is the highest standard of mental culpability. This is hard to prove, right? It's really hard to prove because you're not going to have contemporaneous direct evidence. You're not going to have commanders on recording saying, hey, go attack civilians right now. It's just not realistic. You're going to have to rely on what? Circumstantial evidence. And what circumstantial evidence are you going to look at? Well, obviously, you're going to look at the effects of the attack. But this is what I meant about being careful about effects-based condemnations. In war, if all you do is look at the fact that a civilian building was destroyed or civilians were killed and draw an ipso facto conclusion that the defendant intended to attack civilians, you're creating a strict liability standard that no commander could ever comply with. Mistakes happen in war. They happen all the time. Commanders make bad judgments. A bad judgment is not intending to attack civilians. It may violate the reasonable commander standard. It may get you prosecuted in a court-martial for a reckless killing, but it's not an intentional attack on civilians. This is going to be a big challenge for the prosecutor. Now, I'm just finishing up an article I'm going to do over in Israel where I'm going to make the argument that when can effects alone ever qualify as sufficient proof of intent? I think the answer is yes. There's a phrase in the law, I mentioned yesterday, lawyers for some reason love to speak in dead languages, right, Latin. There's a phrase in the law, res ipsa loquitur. The thing speaks for itself. I think what we're seeing in Ukraine, in many cases, you're going to satisfy that standard. A prosecutor is going to be able to look at a building, say, we've got video of it. There was no fire coming from the building. The enemy wasn't in the building. There is no plausible basis to conclude that building was a military objective, and yet they bombed it. The only rational inference you can draw from that is that the enemy was intending to attack civilians or civilian property. So I think that's going to be the challenge. The other thing I think that is going to be highly relevant in this evidentiary equation is all the opportunities the Russian commanders had to mitigate risk that they ignored, right? Because the less you do to mitigate risk, the more likely it is you don't care about the consequence of your attack. And I think that this is going to be a big issue at the ICC. I think they are going to indict Russian commanders for launching indiscriminate attacks and illegal attacks, and they're going to have this evidentiary challenge. And if we look at collateral damage, it's even more problematic. This is the proportionality rule. The attack was such that it would cause incidental death or injury to civilians or damage to civilian objects or widespread long-term and severe damage to the natural environment and such death, injury, or damage would be of such extent as to be clearly excessive. So they've made it even harder. The operational norm is excessive. I don't really understand what clearly excessive is. It's like when people say imperative military necessity. Well, I thought military necessity, it's kind of, it's superfluous, right? But what's clear about the rule is that to criminally sanction someone for a disproportionate attack, the imbalance between military advantage and civilian risk has to be off the chart. And why is this one so hard? Because unlike the other one, attacking civilians, this one presupposes you're attacking a lawful target. Because you're being punished for attacking a target when you shouldn't have, because of the risk to civilians. And then look at the mental element. The perpetrator knew the attack would cause this level of incidental injury or collateral damage. That's not an easy burden of proof to satisfy. The point of all this is to just tell you that, or suggest to you, that there is definitely a difference between condemning the conduct of hostilities as violation of international humanitarian law and convicting somebody for a violation of international criminal law. They are not the same thing. And we should not use this standard as the operational standard. It's too demanding. The reasonable commander standard is the right standard. And by the way, when they drafted the treaty, they debated this. And there was some discussion about adding recklessness as a standard. So if you recklessly launch an attack, which would be the operational standard, but the drafters rejected it, because they want the war crimes accountability to be limited to only the most grave violations of international law. The point is, you can violate the law without violating the ICC statute. And the prosecutor knows that, and that's going to be a factor in the equation. Now, and I just spoke about that. Very briefly, what are the U.S. options? The United States actually has a war crimes statute. It's called the War Crimes Act of 1996. It's a federal criminal statute. When we ratified the Geneva Conventions in 1956, the 449 conventions, they all have a provision called the grave breach provision. A grave breach of the Geneva Conventions are a list of violations that are considered the most grave, the most aggravated. Murdering civilians, medical experimentation, collective punishment. And the treaty said, every country that adopts this treaty, have to provide for the criminal punishment of any person in your jurisdiction who committed a grave breach. That's a manifestation of what international lawyers call universal jurisdiction. There are some crimes, some violations of international law that are so serious that they offend every nation of the world equally, like piracy, crimes against humanity, genocide. So I don't have to have any nationality connection to you. If I find you in my jurisdiction and I think you committed a grave breach of the Geneva Conventions, I have a treaty-based obligation to punish you criminally. And Congress, so 1956 they ratify the treaties, and they get right on top of it, and 40 years later, in 1996, they enact the War Crimes Act to implement our obligation under the Geneva Convention. And they don't even make it universal jurisdiction. They limit the jurisdiction. You have to either prove that the perpetrator or the victim was a national of the United States. Now, Congress right now is considering a new bill, the War Crimes Accountability Act, that would do two things. Number one, it would make the War Crimes Act consistent with universal jurisdiction, and it would add crimes against humanity to the list of crimes within the jurisdiction of a federal prosecutor. I think that's really important to do. I've written about it. I wrote a statement for the Senate Judiciary Committee, because it's not uncommon for people who've been in wars 5, 10, 15 years later to end up in the United States. And if we find some Russian who was a battalion commander who ordered the indiscriminate attack of civilians, why should it matter if he's driving a taxi in New York that his victims weren't American? Why should it matter that he wasn't American? If we're serious about implementing international criminal responsibility, we'll change that law. Do I think it's going to happen? No. And I think the midterms are going to make it even harder for it to happen. And the reason is because there are members of Congress who are afraid that that will encourage other countries to do the same thing to our people. My reaction to that is, what are we afraid of? If we have a soldier who commits a grave breach of the Geneva Conventions, we're the ones who should be prosecuting him. And if we don't, and there's really good evidence against him, then we shouldn't complain about it. He's not a hero. He's a villain. Of course, I was a prosecutor, a military prosecutor, so I believe in holding people accountable when they cross the line, because if you don't do that, in my view, you diminish the fidelity of the tens and hundreds of thousands of American men and women who've gone into the worst situations imaginable and followed the rules. And to me, for the American military, that is the ultimate tragedy of war crimes. The ultimate tragedy of war crimes is it diminishes the courage it takes to hold that line, to see your enemy as an object of violence one minute and an object of humanity the next minute. That's not easy, and that needs encouragement. And so I really have no problem prosecuting American war criminals. And I don't think Congress should either, but I'm not a congressman, and I never will be. So we'll see what happens. So we're limited in our ability to act domestically, and we're certainly limited in our ability to influence the ICC because we're not a party member. And that's what I wanted to go over with you. I hope you found it interesting, and I would be happy to take any questions if we've got some time to do so. Good? All right.
All right, so if you have a question, Jack and Adam here will bring the microphone to you.
Come on, let's get into it. Fun part.
Hello. Thanks for that, and thanks for our talk yesterday. It's been a pleasure having you here. I have two questions. I'm not sure which one to ask. One's more kind of procedural and perhaps a more straightforward answer, and the other one is perhaps more interpretive, but it does relate perhaps to this question here, so maybe I'll begin with that. I was hoping you could talk more about like the irony and the real risk, the extent to which the United States refuses to participate or is limited in its participation in this form of international justice, and the extent to which that reflects a broader sense of American legal and historical exceptionalism. It recalls to me the title of a book by a woman named Elizabeth Cobbs Hoffman, which describes how the U.S. created an international rules-based order and served as the umpire. The title of the book's American Umpire, not Empire. Get it? Enforces those rules, but also doesn't have to play by the rules. And how you see that shaping not just the legal relationship the United States has to other nations or how they might deal with U.S. war criminals at home or abroad, but how that might also generate resentment and initiate further problems for the United States and the world arena itself.
No, listen, we had this conversation a little bit yesterday,
Yeah.
and I think the United States, in its policy decisions, often can be its worst enemy, and it can give ammunition to tyrants. We talked about, for example, the prior administration's decision to endorse the Israeli annexation of the Golan Heights. Now, we can debate all day whether the West Bank is really occupied or it's under just occupation administration, and it was biblical. The Golan Heights, there's no debate. That was territory that was taken by military conquest, and the Geneva Convention the Fourth Geneva Convention on occupation is clear. You're not allowed to unilaterally change the legal status of territory that you conquered. But what do you think Putin is arguing in eastern Ukraine? I'm just doing what the Israelis did on the Golan Heights and what the Trump administration said is okay. I also think, and I don't know if you and I had this conversation, I know I talked about it a little bit yesterday. There is a myth that the United States doesn't hold its forces accountable for war crimes. A myth. What we don't do is charge them with war crimes. Now that's a common sense prosecutorial judgment, because anything you can point, almost anything, you can point to in the ICC statute is a crime in the Uniform Code of Military Justice. Killing a prisoner of war is a war crime. It's also murder in violation of Article 118 of the UCMJ. Sexually assaulting a civilian in the battle space is a war crime. It's also rape in violation of Article 120 of the UCMJ. If I charge murder or rape, I don't have to prove the Geneva Convention applies. I don't have to prove we were in an armed conflict. I just prove the elements of the traditional common law crime. I think that we need to change that. And I wrote an article last year in the American Law Review, Strengthening American War Crimes. And one of the things I argued with a friend was, Congress has already done this for the enemy. The Military Commission Act of 2006 enumerates war crimes for the Taliban and Al-Qaeda. Why hasn't Congress incorporated that into the Uniform Code of Military Justice so that at least a commander has the option, a prosecutor has the option? Let's actually charge this as a war crime, because there's a signaling message that matters. There's a legitimacy message that matters. And you know, it's interesting, your point about how this undermines credibility. The Bible for American military operations is Joint Publication 3-0, Joint Military Operations. And that doctrine lays out what are called the principles of effective military operations, joint operations. Unity of command, economy of force, mass, security, surprise, all you know what they added about 10 years ago? Legitimacy. Legitimacy, they say in the doctrine now, DOD doctrine, legitimacy can be the decisive aspect of military operations. And legitimacy is defined as the actual and perceived legality and morality of operations. So I will tell you that in 2001, having taught at the JAG school for 3 years, where I was teaching JAG lawyers how to follow the rules, and then I'm in Germany as the chief of international law for U.S. Army Europe, and we find out that there's an aircraft coming from Bagram, Afghanistan, that's going to refuel in Ramstein Air Force Base, and no one's allowed around it because it's got hooded detainees chained to the floor of the aircraft on their way to Guantanamo. I had former students who were working with me saying, "Sir, how can this be right? How can we be doing this?" And you know, I gave the standard, I'm just a cog in the wheel answer. Like, I don't know all the facts and circumstances, but I will tell you that as we started to kind of progress into a more normal state, right, with help from Congress, with help from the Supreme Court, Hamdan v. Rumsfeld, there were silent screams of joy in the Pentagon that the courts and the Congress are putting brakes on the executive for telling us to do things that are of dubious legitimacy. And so there is a price we pay. And, you know, in my view, and I was talking with some students this morning, because last night I was teaching a class on military commissions on Zoom, and we did the Balul case, where then Judge Kavanaugh basically says international law has no constraining effect on the executive. None, right? Or Congress. If Congress wants to enact a law that is in clear violation of customary international law, that's our sovereign prerogative. Why would we as a court constrain our government with what other countries think? It's a tortured understanding of international law, and it reflects, I think, from the inception of this nation, the schizophrenia we've had with international law. You know, one of the first laws we enacted was the Alien Tort Statute that allows aliens to come into our court to sue other aliens for violations of international law. I ask my students all the time, why would the first Congress have enacted that law? Like, why do they want some, you know, Yemeni to be able to sue another Yemeni in the United States for torture in Yemen? Because our founders wanted to signal to the rest of the world we're bona fide. And one of the ways you prove you're a bona fide member of the community of nations is you show your respect for what? International law. But from the beginning, it's been this friction between our own sovereignty, and I agree with you. I think there are a lot of conflicts, and I can tell you personally, when you're in the middle of it and you're trying to understand this, it can be demoralizing. And then what do? You try and affect what you can affect, you know, your sphere of control and your sphere of influence. And I think that the Military Legal Corps did a pretty good job of doing that, of limiting the negative impact of a lot of these decisions. With the ICC, I think the jury is still out on the tribunal. I think that what happens in Ukraine and Israel right now are going to be decisive for the long-term credibility of that tribunal. And I can tell you that there are other NATO allies that are have been getting a little bit concerned about the tribunal. So we'll see what happens. I think they can earn a lot of respect over the next 4 to 5 years if they handle these cases properly. If they just simply say, well, look at all that destruction, you must be guilty of a war crime, people are going to reject that credibility.
Thank you.
Yeah.
Yeah, Geoff, thank you so much for your talk. I really appreciate it. Earlier you had mentioned that the rule of law dictates that the killing of civilians is permitted so long as it is proportional and not excessive.
Correct.
And I'm just wondering, how is there a point, like, are this many civilians allowed to be killed
No.
for this level of high-ranking official, or to what extent are these different factors kind of calculated?
So it's really a fascinating question. What we did in Iraq and Afghanistan, we, the United States, is we implemented what were called civilian casualty thresholds. So what it meant was, if you were a battalion commander, you commanded 500 soldiers, you were permitted to authorize an attack if the anticipated civilian casualty number was 5 or below. If you were a brigade commander, 10 or below. Above 10, you had to go to the division commander. Now, that was widely misunderstood, because the danger of that is what? A battalion commander is always allowed to kill 5 civilians. That's not what it meant. It simply meant, we trust your judgment up to this point, right? Beyond that point, we want a commander with more experience, more judgment, more legal advice, and most importantly, more resources. Because that commander might look at the situation and say, no, I can avoid that by doing something else that you can't do. So that has been one of the ways we've tried. That's actually a precautionary measure. Process itself is a precaution that makes the decision-making better. But ultimately, even when you hear in the news something like a CDE, a collateral damage estimate, like if we're doing pre-planned targeting, we know what the targets are, then the weaponeers and the operations and the intelligence, they get together and they do a dossier on every target. And it says, here's the target, here's the weapon we propose to use, here's the blast radius, here where the civilians are. They do a CDE estimate so they can present it to the commander. That doesn't mean you're allowed to kill that many civilians. Every decision is ad hoc. And personally, it's why I think that precautions have always been the neglected cousin of the rules of decision-making, because proportionality is so amorphous. I've had the experience. Imagine you're a lawyer and I'm your commander, and you say to me, sir, you're only allowed to attack that target if you conclude that the civilian risk is not excessive in relation to the military advantage. You know what your client is going to ask you? What is excessive? And then you're going to say what? Sir, that's up to you. That's a subjective judgment, right? It's not very, okay, if it's an enemy cook making pancakes in a kindergarten with 50 kids, what moral commander is going to say attack? And if it's Osama bin Laden in his house with 3 family members, most commanders are going to say that's an acceptable price. But outside the realm of those extremes, it's amorphous. So if we really want to protect civilians, we need to be emphasizing that middle step, precautions. And by the way, to that end, about 2 months ago, Secretary of Austin announced a brand new initiative. It's called CHIMRAP, Civilian Harm Risk Mitigation Action Plan. And DOD is creating a precautions center of excellence, where they're going to be looking at every tool in the book that we can give commanders to help them do what? Bring their enemy to submission in a way that mitigates risk to the civilian population. That's how we protect civilians in war.
Thank you so much for that. Just a quick follow-up is something like, for instance, the killing of Zawahiri. This occurred when the Taliban and the Afghanistan government were in the midst of peace talks. Like, is that something that's going to be factored in, that this has the potential to disrupt those negotiations?
I mean, I would hope it's factored in, right? But that's not a legal question. So when I teach lawyers, I emphasize this all the time. If just because it's legal doesn't mean it's right. If it's illegal, it's always wrong. I don't want to hear the argument, it's illegal, but we have a that's Alan West, who to me was a disgrace. You know what I'm talking? He's the head of the Texas Republican Party, and he was a congressman from Florida. And he I used to watch his campaign videos where he's talking about threatening to assassinate a detainee, and he's got soldiers saying, we're glad he did it. No, that's not good. You make so many more terrorists. So what I would say in response to that is that's a really important strategic decision. The first step in that decision is having a lawyer advise you on what you're allowed to do. So if he's under a flag of truce, you can't attack him, sir. Sorry, can't do it. It's illegal. If it's legal, then, yeah, does the lawyer play a role as a counselor? Sir, I'll give you a specific example. At the end of the first Gulf War, we had gone through every target on the military loves acronyms, right? Here's one you never heard of, the JPITL, the Joint Prioritized Integrated Targeting List, right? We had addressed there was nothing else to attack. That's how badly we beat the Iraqis. But there was one thing near the bottom, the Victory Arch in downtown Baghdad. So a JAG colonel, Ray Rupert, went to the meeting, and they were proposing launching an air attack on the Victory Arch. And he said, why? Why are you doing this? And they said, but couldn't we say it's a military objective because it was designed to encourage the military? He's like, they have an arch for victory in a war they lost to Iran, and you think that you're going to get some advantage? And he said, but anyway, it doesn't make sense. You don't just attack something because it's there. You have to get something out of it. And then the funny thing was, he said to them, they said, well, you know, it'll hurt enemy morale and it'll show that Saddam Hussein is weak. He said, what if you miss? And then they took it off the list. So there's legal and there's policy. I think what you're asking is a policy judgment, which I mean is really important. And I will tell you, in my experience with the colonels and generals I worked with, they're smart people, they're moral people. They don't want to hurt or destroy if they can avoid it. This was I never, and I worked, 101st Airborne Division, 508th Parachute Infantry Battalion. These are hardcore leaders. I never encountered a leader I felt was immoral. I felt that they knew what their duty was, and they were ready to unleash violence to achieve the mission, but they were always thinking of how can I do it in a way that mitigates suffering. And those are the type of leaders we want to develop. That's that little article I sent you, right? That's the type of leader we should encourage and reward, not the Alan Wests of the world. It's on tape, so he'll probably come hunt me down in Lubbock, put a gun to my head. Anything else?
My question is, it's a pretty straightforward one, about what is the process now for the International Criminal Court? Isn't there someone from there already in Ukraine, like collecting evidence?
Yeah.
And so you said 4 or 5 years. Is it going to take 4 or 5 years to? What's the process going forward?
He's opened a preliminary inquiry because the state parties requested it, correct? He didn't have to get permission. This is Khan, the new prosecutor. And there's a whole structure for doing it. He's gathering evidence. He's got a lot of help from the United States in gathering evidence. He's got a lot of help from NGOs in gathering evidence. The AP is part of this. They're gathering, this thing has changed the nature of war crimes accountability. Fundamentally. There is so much video evidence of what the Russians have been doing. Now, what's going to take a long time? Number one, the joke, the funny term we use is somebody's got to put the habeas grabus on some of these guys, right? They got to grab the body. So the first problem is, how do we get Russian leaders in front of the court? They have to have physical jurisdiction over them. And then the process is just long and laborious. If you look at the cases that the ICC, the ICTY, the ICTR, the Tribunal for Rwanda, for Yugoslavia have done, they take forever. And that's because, as I mentioned earlier, these tribunals are kind of like Frankenstein. The international community has taken different legal theories and traditions from all different parts of the world and sewn them together, and then you're trying to make it work. And I've been a witness in one of these tribunals, and I was stunned by how inefficient it was. And so this was my point earlier today when we were talking, and I said, I think one of the pieces that we have to be very careful about is not seeing the ICC as the singular source of criminal accountability for war crimes, which is why I want us to amend our war crime statute, so that we could play a role. Every country should play a role. These violations should offend every nation equally, and I think that there could be more efficiency if individual countries were to get involved in holding some of these people accountable, because the ICC is not an efficient process.
If I could add one more body part to Frankenstein then. What about where in this ecosystem of criminal accountability do private contractors fit? Because some of the worst news stories I remembered hearing about assaults on civilians, particularly in Iraq, involved private contractors. Yeah. Not necessarily military personnel, very often former military personnel, yeah. But where do they fit? Yeah,
PMCs we call them, private military contractors, the Wagner Group, Blackwater. So in the International Criminal Court, you can be prosecuted for being a mercenary. A mercenary is defined by Additional Protocol 1 as someone who fights for private gain and is compensated substantially more than the average soldier, whatever that means, right? Nobody has ever been prosecuted for being a mercenary. More likely what will happen is if the Ukrainians capture them, they will say, you don't qualify to be a prisoner of war, which means we can prosecute you for violating Ukrainian law. If you're a prisoner of war, you get something called combatant immunity. You're immunized from criminal sanction for your lawful wartime conduct. Like people say, why would you ever want to be a prisoner of war? Well, I'd rather be a prisoner of war than be a detainee who's not a prisoner of war, because I get protected from the state's jurisdiction. Okay, this was, remember John Walker Lind? There was a big issue in his case, because he said he was a member of the Taliban armed forces, which meant he was a prisoner of war, and he was breaking out of a prison, which meant we were not allowed to prosecute him for murder of an American official when he killed Michael Spann, the CIA officer. And the district court in Virginia said, no, you don't qualify to be a prisoner of war, so you don't have any protection. Okay, so that's probably what will happen with them. For us, it's a very interesting story. Congress enacted a law called MIJA, the Military Extraterritorial Jurisdiction Act, which is not really what it sounds like. It should really be titled the Hanging Around with the Military Extraterritorial Jurisdiction Act. But what it says is if you are a civilian who is working for the military during a contingency operation and you do anything that would be a crime in exclusive federal jurisdiction like Yellowstone Park or Washington, D.C., you can be prosecuted in a federal district court. And the Blackwater prosecutions were done under MIJA. The other thing that Congress did without DOD asking them was very interesting. They amended the Uniform Code of Military Justice to give military courts martial criminal jurisdiction over civilians who accompany the force. Now, historically, we did that. I mean, all the way back to the American Revolution, they were called sutlers. Those were like the contractors that came, you know, in the Civil War. There was no mortuary services in the military. You would, before you went into battle, you'd do a little contract with an embalmer in the compound and say, if I get killed, please take care of my body and send it back to Gary, Indiana, or whatever. And so there were always contractors with the military, and they were always subject to military jurisdiction. But in 1972, the Court of Appeals for the Armed Forces said you can only do that if there's a declared war, because that's what the UCMJ says. It says in time of war, and anybody know when the last country we declared war against? One of my favorite trivia questions. What? It was World War II. What was the last country? Romania. Because it was at the bottom of the Axis list. In January of 1942, we declared war on Romania. That's the last time we formally declared war. So when I used to teach this at the JAG school, I would say, we're never going to court-martial a civilian again, because we're never going to declare war again. In 2006, because of Blackwater, Congress changed the military code and said you can prosecute a civilian in time of war or any other contingency operation. That means an operation ordered by the Secretary of Defense, and we've done it. We've court-martialed some civilians. I personally think that's wrong, right? Because if you're court-martialed, you don't get a jury of your peers, you don't get indictment by grand jury, you don't get a life-tenured judge. You get all the other things, Fourth Amendment, Fifth Amendment, right to counsel. But my view is we've got media. So if you're a civilian who commits a crime in Iraq, let's bring you back to the federal district court in New York and prosecute you in a civilian court. But so far, this has been upheld by the military courts, and there have been a couple of civilian contractors who've been prosecuted for things like downloading kiddie porn while they were on a military mission, or getting in a fight with a soldier, and then they get prosecuted for aggravated battery. So Congress has two now very significant changes to the law. And I will tell you, I told you I was the chief of international law in Europe, and we had a case of a contractor in Kosovo with the military who raped a local national. And it was a dilemma. We couldn't court-martial him because he wasn't in the military. He didn't commit a federal offense because he was in Kosovo. And, you know, are we going to really turn an American citizen over to this nascent Kosovar criminal justice system? To his credit, four-star General Montgomery Meigs said he's not getting away with it. Turn him over to the local nationals. If he did, now he was acquitted because the victim recanted or something. But at least now, as the JAG, I can go to the commander, I say, you got two options, sir. We can turn him over to the FBI and they'll bring him back to Virginia and a U.S. attorney will indict him, or we can actually convene a court-martial and prosecute him for violating the UCMJ. Can I tell you one more trivia story? Montgomery Meigs was my commanding general. His great-grandfather was the quartermaster general of the Union Army when the Civil War began. And when the Civil War began, we didn't have any national cemeteries. So Lincoln ordered General Halleck, the commander of the Army, find an appropriate place to intern the casualties. And Halleck went to Montgomery Meigs I and said, find a place. He said, I've got the perfect spot, Mrs. Lee's Rose Garden. And that's how Arlington Cemetery began. That was his great-grandfather that chose Arlington Cemetery as a way, that was the Lee house, that beautiful house up on the hill. Incredible trivia. And that every descendant after that became a four-star general in the Army, including Monty III. That was not too interesting to you. Anything else? Yes?
Maybe this is more a Nuremberg type thing. I mean, if you make the argument that the Ukraine war itself is illegal, what are the implications for, well, all these civilians died, all of that was a crime because the war shouldn't have happened at all?
Yeah, you know, I have a friend who teaches at Southwestern Law School in LA. She's a retired Air Force JAG. And she wants to write an article making the argument that a crime of aggression is a crime against humanity. So that you don't have to, you can allege it as a crime against humanity. Now, why is she thinking that way? Because aggression is not a crime before the ICC yet. They recently added it, but it's purely consent-based. So only countries that are party to the treaty that agree to be bound by the aggression crime. And there's a guy in England, his name is Philippe Sands. He wrote a book about Guantanamo called Torture Team. And he's a big human rights lawyer and activist. And he's really pushing now, with the support of the Ukrainian government, for the international community to create a new tribunal, an ad hoc tribunal for Russian aggression. But that's a problem, right? All of the crimes right now are focused on the actual conduct of the operation. There has not been an aggression charge since Nuremberg. and it's been very controversial at the ICC to add that charge. Now, there are ways to reach the leaders for the war crimes that are committed by their subordinates. There are doctrines to do that. But I think unless there's an ad hoc tribunal created, a new tribunal, you're not going to be able to prosecute Putin or his leaders for aggression. Well, thank you again, especially you. This has been fun.